So you just got the notification that the military is trying to administratively separate you. You have enlisted, you served a part of your contract, and now it looks like you're about to get kicked out early. That feeling of being separated too soon is something that I'm familiar with because I've been able to help clients in that particular situation. And in this video, we're going to talk about what an ADSEP board is, how they work, and some of the rights that you have at that board. My name is Kevin Courtney. I'm a former Marine Corps judge advocate and the founder of the Courtney Military Law Group. I help and defend enlisted Marines, airmen, soldiers, Coast Guards, sailors, and Space Force guardians around the country and around the world at ADSEP boards in order to protect and defend their honor and reputations. An ADSEP board is essentially an employment hearing where the military is trying to separate you and say, we appreciate your time. However, we believe you did something wrong, and we're going to try to prove that that misconduct is a reason that you should be separated. Now, at an ADSEP board, there are several rights that you have. First off, you have the right to counsel. You have the right to a free judge advocate who's going to be detailed to you if you're going to an actual board, because there is a no board opportunity that the command can do if you've served less than 6 years. But if you're facing an ADSEP board where you get a hearing, you also get an attorney. If you want to have outside counsel, you can have a civilian join your team. In addition to the right to counsel, you have the right to call witnesses, present evidence, and make a statement in your own behalf. You also have the right to question some of the members. We call this voir dire. All of these rights are provided to you in advance so that you can prepare for your case. The day of the board, I typically block off about 7 to 10 hours because it's a full day, full press event. Early on, you're going to walk into the boardroom and you're going to have your binder of evidence that has been prepared, and you are going to sit down at the counsel's table with your attorney. And once that record goes, they click start. Your attorney is going to help defend your case. The government has to present evidence to meet 3 different questions. The first question is there basis? The thing that you've been notified of the allegation of, the government has to present evidence to meet basis. Now, the burden of proof is about 51%. It's more likely than not. And so they have to show that the alleged misconduct occurred based on the evidence, either in the documents or when they call witnesses. So knowing that that's their goal, the command has sent members to sit on the panel. And when you walk into the room, you get an opportunity in your team to question these members. The whole point is to make sure that they are fair and impartial. And you'd be surprised at how often you get members who are really there to do the right thing. And the right thing could be to evaluate the evidence in a way that is favorable to you. It might be to critically evaluate some of the holes in the government's case. But either way, if they have a bias that prevents them from being fair, your attorney gets to ask questions, solidify that bias, and then your attorney gets to challenge the member so that a new member could come and sit and then vote on your case instead. Once this process is complete, which again is called voir dire, once voir dire is complete, the government is going to make an opening statement. Their opening statement is designed to tell the members what the evidence is supposed to look like. Evidence has not yet been admitted, but they're essentially telling the members what this case is about. Then your attorney gets the opportunity to stand up and make your opening statement. This is critical. It's the opportunity to tell the members what evidence you are going to present, if you're going to, or the holes that might be in the government's case. Either way, it's your opportunity to present your theme and theory of why either no misconduct has occurred or why you should be retained nonetheless. After both parties have made their opening statements, then each side gets to present its documentary evidence. The documentary evidence could include your awards, character letters, any kind of evidence that comes from an investigation of some sort. But once that evidence has been admitted, the members typically are going to break. They're going to go back into the deliberation room and review that evidence. You get the opportunity to take a break as well with your counsel, call your character witnesses, make sure everybody's aligned and ready to go. And when you come back, typically an hour or 2, maybe 3 hours later, that is when you and your team get into the witness portion of the day. The government starts by presenting its witnesses. If they have any fact witnesses or character witnesses, they're going to call them. They're going to do what's called a direct examination. That's pretty much an open-ended set of questions. And then once they have finished, your attorney gets to get up and cross-examine them. After that has occurred and the government has rested its case, it switches over to you and your team. Your team gets the opportunity to call witnesses who know the facts of your case or know you and your character. The fact witnesses and character witnesses build upon the evidence that you've already presented to the board members. At any point when the government or your attorney is questioning these witnesses, the board members can also ask questions. It's pretty much all three sides going to find the truth, try to find the evidence that allows you to be retained. Once all the witnesses have been called and you decide to rest your case, that's pretty much when the case is over and the two sides get to make their final arguments. In this closing argument, the recorder who represents the government is going to argue likely that basis has been met, that you should be separated from the service, and that potentially your service should be characterized as other than honorable. The three different types of characterizations that are available are going to be honorable, general under honorable, and an other than honorable. And if you have questions about the different types of discharges, I did a video up here. You can take a look at that one. But the worst thing that could happen at this hearing is the board members vote to separate you and have an other than honorable. If you have not served any other honorable enlistments, the OTH is going to characterize everything. That's going to be the characterization that the VA uses to determine if you get VA benefits, like the VA home loan, VA disability pay, VA healthcare, and most importantly for so many military members, the GI Bill. Once the government has finished its closing argument, your attorney gets the opportunity to get up there and make the final argument. That argument is the theme and theory, the evidence, all wrapped up into one cohesive thought. This argument is presented to the members, and it's critical to make the eye contact in order to show them that this is serious for you, and you're taking this as if your career is on the line, because it is. Once your attorney has finished the closing argument, the government gets its final opportunity because they have the burden of proof, and they make what's called a rebuttal argument. Typically, a rebuttal argument is focused on any points that were not addressed in the opening, but your counsel decided to raise. After that point, once the rebuttal has finished, the board members are going to go back and deliberate. So the hearing has been closed, and the deliberation process occurs. This could be as fast as 7 minutes, as long as several hours. Typically, the members are looking at all the evidence that has been presented from the government, has been presented by you. They're going back and looking at their notes from witness testimony. And then once they have decided a decision for all three questions, they will reach back out to your attorneys, bring everybody back to the room, and then they're going to announce the decision. At this point, your career that has been probably being held over your head for several months as this process has taken place, they're going to read out whether the burden of proof has been met for the first question. And so if the burden has not been met and basis has not been met, that's going to be the end of the inquiry, meaning no misconduct has occurred, and therefore the automatic default answer for question 2 is retention. You get to stay in the service. If for some reason the misconduct has been substantiated, they go on to question 2 and they say, we found basis, but we get to determine if you're going to be retained or separated. Now, this question is based on several factors, and every service has retention factors that are supposed to be considered. If your attorney provided evidence that shows despite misconduct, you are worthy of retention, that is a true, viable outcome. However, if the board members determine that the misconduct occurred and separation is still warranted, they then have to go to that final question, which is, have you earned an honorable, a general under honorable conditions, or an other than honorable characterization of service? With these three options, VA benefits are going to be riding. And so it's incredibly important that when you are thinking about an ADSEP board and whether you want to waive the board entirely or present certain types of evidence or certain types of arguments, it's not just, do I want to focus on question 1? It's a long-term strategy. Because if you go for question 1 and say there's no misconduct, but then they find misconduct, board members might try to punish you in the sense of This person did not take accountability, said it didn't happen, yet I had evidence that it did, and therefore I think this person has earned an other than honorable characterization of service. Regardless, if your board has a faulty process or the evidence wasn't sufficient at a particular point and the members made note of that, yet came to a different conclusion anyway, your attorney has an obligation to put this information on the record. And if you wanted to, you could then upgrade your discharge later on using the record that your attorney has created. So it's incredibly important that after all of the hearing has completed, at the end of the day, the audio recording or any written recording that has been published, you should ask your attorney for a copy of that, especially if there's some sort of separation decision or a characterization decision that's not an honorable and you want to change that going forward. If you need a discharge upgrade, I did a video up here and you can look at some of your options. But for ADSEP boards, the three main questions that members need to remember is going to be, is there a basis? Should the member be retained or separated? And if separation is necessary, is it an honorable, a general, or an other than honorable? If this information has been helpful for you, like and subscribe to the channel. And if you would like to discuss your case, understanding that time is kind of the essence, knowing that your career is on the line, feel free in the link in the description below to reach out to me and my firm. Our team can help you and figure out what's the right strategy moving forward. I'm happy to talk. Again, my name is Kevin Courtney. I'm a former Marine Corps judge advocate, and I look forward to connecting with you.